So you're thinking about making a will. In this video we go through the various factors you need to consider when making a last will and testament. Hi and welcome to Legal Connect, the channel which helps you, the consumer, choose the right lawyer by location, price and service. So you're thinking about making a will and want to know how it works. Well, in this video we meet Davina Charlton. Davina is a specialist wills, probate and private client lawyer who answers our questions on all things related to making a will. Now, just before we start, here's a quick disclaimer. Legal Connect is not a law firm, and this video does not constitute as legal advice. It's simply an overview of various options for you to be aware of and has been made for the purposes of entertainment only. Now that's out the way, let's get on with the interview. We started by asking Davina why someone should make a will in the first place.
So a will is obviously very important. People think, oh, I'm not old enough yet to do a will, but any age you should write a will. So a will is where you decide how you want your estate to be inherited and who you want to deal with that. So who would you want to administer the estate? They're called an executor. So you can dictate exactly where you want all your worldly possessions to go. If you didn't have a will, it would go through intestacy, which is quite an old-fashioned rule. And sometimes you might be estranged from certain family members that could benefit from intestacy. Whereas if you wrote a will, you know that it could go directly to beneficiaries. Also, for example, if you've got children, if you sadly passed away before they're 18, who's going to look after those children? You can name a guardian, so you know that they're going to be cared for by the people you choose. You might have a particular love for a charity that you'd want to benefit from your estate. You might have even pets that you want to provide for. If you wrote a will, all your wishes could be named in that document, and your executors would be legally obliged to make sure those wishes are carried out.
This led us to ask what would happen if someone passed away and they hadn't made a will, which is known as intestacy, and how that could impact someone's loved ones.
So, intestacy is the law, which is quite an old-fashioned law, is what will happen if you don't have a will. So it would look at your next of kin. So if somebody passes away, they'd see who that next of kin was. So if it was a woman, for example, is she married? It would go to her husband. If she is married and has children, depending on the value of her estate, would depend who inherits what. So the law changes slightly on this. So if you are a married couple and your estate is over a certain amount of money, some could go to the children and some could go to the surviving spouse. If, for example, you weren't married, you had children, it would go to children. If you didn't have any children, it could potentially go to grandchildren. Then if you didn't have any, it could go up the generation to parents, then it could go to siblings, aunts and uncles, cousins. It's a very old-fashioned rule, and it only deals with bloodline. So if you were a couple that weren't married, had been together for years and years and years, if you hadn't made a will leaving your estate to that person, they wouldn't inherit from their estate. It can be a lot more difficult to deal with the administration of the estate. If you have a will, you appoint your executor. So your executor is the person you appoint and is legally entitled to deal with the estate. A will can show who the executor is. If you don't have a will, your administrator would be the person dealing with your estate. So similarly again, it will be the next of kin. But because there's no will in place, they're not legally entitled to do it. They would have to make an application to court to prove that they're the administrator. So it can be a lot more lengthy process in order to start dealing with the estate. Some banks, for example, if you had a will in place, would release the monies to the people entitled, whereas if you didn't have a will in place, they can't prove who is entitled. And also, if you don't have a will in place, somebody might come and say that they are entitled to the estate, but really they're not. But there's nothing legally there showing that's the case until you make an application to court.
Now we know why it's important to have a will and the potential impact of not having one. It begs the question how someone can actually go about making a will.
There's a variety of ways. Obviously, we would always recommend taking legal advice depending on the circumstances of your estate. People think it can be quite easy, but a lot of the time your estate and your family circumstances are a lot more complicated. So yeah, of course, take legal advice, use a solicitor. You can, of course, do a DIY will, do it yourself. There are some packs, even Voucher and Groupon and places like that all offer will packs. You can get will writing firms that could offer a service to deal with wills and other estate planning issues. You can also get a free will through a charity where the charity will either sort that out themselves or they would have a list of solicitors that they would recommend you use. They're not always free, the charity wills. Sometimes they are on the provision that you leave something to that particular charity in your will. Sometimes the charity will subsidise some of the costs towards the will, so it will be reduced. It all depends on that individual charity and scheme that they're using.
Although Davina has just explained a broad overview of the various options available to you, if you want to find out more about these choices and their respective pros and cons in more depth, check out our video on writing a will and testament, where Davina does a deep dive into each of the options available to you. There'll be a link to this at the end of the video. But for now, let's look at what people should consider when making a will.
So I always say to clients, you need to consider if you've got any specific funeral wishes, if you'd want those to be followed in your will. They don't have to be included in a will. Funeral wishes are only wishes, they're not legally binding, so they can be done separate. You need to consider who you'd want to appoint as your executor. So your executor is in charge of dealing with the administration of the estate. So making sure the funeral's dealt with, that all bills are paid, that all monies are collected in, and then effectively to make sure the wishes of the will are carried out. If you have young children, if anything happened to you and their other parent, who would you want to be the legal guardian of them? You also need to consider if you wanted to leave any specific gifts. This could be gifts of personal items to anybody. If you wanted to leave set amounts of money to charities, beneficiaries, it could even include a pet. If you have a pet that you wanted to ensure was cared for if you passed away. And then ultimately, who would you want to inherit your estate? So all your worldly possessions, where would you want them to go? And a lot of clients, again, it's not very nice to think of, but if anything happened to your chosen beneficiary, where would you want your estate to go instead?
If you're enjoying this content, please consider liking, commenting and subscribing. Also, if you want to watch videos with other wills and probate lawyers, have a look at our dedicated playlist. But for now, we're back to Davina, where we asked her about a letter of wishes.
So a will is legally binding. Your executors have to ensure the beneficiaries of the will inherit. They're on a legal obligation to do so. A letter of wishes is more of an informal agreement where you're asking the executors to follow these, but they're not under obligation to do so. A lot of the time, a letter of wishes could be, for example, personal items. If you have a number of items of jewellery that you'd perhaps want to leave to beneficiaries, but this is constantly changing. You can update a letter of wishes at your leisure, as long as a copy is stored with your will. Benefit of that is that can be done whenever you want. Any amendments to your will could potentially be charged, and obviously it could get more complicated if it's in the will itself. A letter of wishes can also make your thoughts clear. For example, if you weren't leaving anything to a certain beneficiary, if you were benefiting one beneficiary more than the other, and just generally your thoughts and how you'd like your estate to be dealt with after you passed away, which is more informal, just so your family or your executors are aware.
We thought it might help you to understand the various roles and key terms included when making a will, so we asked Davina to explain the following phrases.
So intestacy is the legal process of how somebody's estate is inherited if they haven't left a will. Administrator is the person entitled to deal with somebody's estate if they haven't left a will. So it's their next of kin. So if somebody doesn't have a will, the administrator would apply to the probate registry for the grant. So the sealed legal document that appoints the administrator to deal with the estate, and that is called letters of administration. So if somebody has prepared a will, they need to appoint an executor, and they are the person they are appointed to deal with the estate, so deal with all the administration of the estate and make sure the wishes of the will are carried out. So if somebody does have a will and they have appointed an executor, the grant of probate is what's issued by the probate registry to the executor, giving them the legal authority to deal with the estate. This is in relation to powers of attorney. So if you were to prepare either a general power of attorney, a lasting power of attorney, or previously prepared an enduring power of attorney, the donor is effectively the person who is creating that document. So attorney is when you're preparing a power of attorney, again, whether it's lasting power, enduring power previously, or general power, is who you are appointing to deal with your affairs. So who are you appointing? They are called the attorney. A general power of attorney is if you've got a specific transaction that you would like someone to deal with on your behalf. For example, if you're abroad and you want to sell a property, you can sign a general power of attorney giving that person authority to deal with that transaction for you. So they'd be able to sign any contract for sale, liaise with the conveyancers on your behalf. That one type of transaction. In a financial sense, you can appoint a general power of attorney to deal with that specific transaction. Now, a general power of attorney is normally only valid for that specific transaction, and if the person ever lost capacity, the general power of attorney would automatically be void. So an enduring power of attorney was the process that was used prior to 2007. So you would appoint attorneys. You could have one person, you could have up to 4 people, and you could state that they could deal with your property and financial affairs if sadly you lost capacity in the future to deal with them yourself. So an enduring power of attorney, although you can't create them anymore, and any signed after September 2007 aren't valid, prior to that, if you've still got them in place, they're perfectly valid. While someone's got capacity, you can legally authorise your attorneys to use your enduring power of attorney on your behalf. If you sadly started to lose capacity, it's up to the attorneys. The onus is on them to register the enduring power of attorney with the court so it can be valid. So if the donor who made the enduring power of attorney had sadly lost capacity or is starting to lose capacity, then the onus is on the attorneys to apply to register the document. So then they'll be able to deal with their property and financial affairs. So lasting powers of attorney is what replaced enduring powers of attorney after 2007. So there's 2 types of lasting powers of attorney. There's one to cover all property and financial affairs, and one to cover all health and welfare decisions. So with the property and finance lasting power of attorney, you would appoint attorneys, so you would appoint people you trust in order to manage your affairs for you. So that could be going to the bank on your behalf, writing cheques, paying bills, speaking to utility companies, pension providers, even sell a property. So any third-party financial account you have, your attorneys would be able to manage either with your authority, if you just wanted a bit of assistance, you couldn't get out the house anymore, or you just didn't want to deal with those things yourself, or they'll be able to deal with them on your behalf if you ever sadly lost capacity in the future. Health and welfare power of attorney, Similar, you appoint attorneys to help manage your affairs only if you haven't got the capacity to deal with health and welfare decisions yourself. So this could be liaising with your GP, speaking to medical professionals, hospital consultants, discussing with social services, care home planning, and the main decision on a health and welfare lasting power of attorney is if you sadly needed life-sustaining treatment, whether you would authorise your attorneys to make that decision on your behalf. So advanced decision, also called a living will, is really similar to a health and welfare lasting power of attorney. If you have specific wishes on how you would be treated, if you have specific wishes regarding life-sustaining treatment decisions, such as do not resuscitate, or the type of care that you would want to receive, if sadly you couldn't make that decision yourself, you would put your wishes in a living will. You'd also put who you would want to be notified if any of those type of decisions need to be made. If you did a living will and then did a health and welfare lasting power of attorney, the power of attorney would override the living will, and vice versa. If you had a health and welfare lasting power of attorney, then did a living will, the living will would cancel out the power of attorney.
We then asked Davina about some of the frequently asked questions she receives from clients.
Will is a privately held document while you're alive. You are under no obligation to tell anybody the contents of your will while you're alive. When you pass away, the executor, it's their discretion whether or not they disclose a will to anybody, the beneficiaries, or even a replacement executor. Once the will goes to probate, it is a public document and can be downloaded from the probate registry. So when somebody passes away and they do have a substantial amount of debt, there is a priority in which what debt applies first. So it would always be funeral, and then it would be secured debts such as mortgages, and then unsecured debts would be right at the bottom. If sadly someone had passed away, their executors wanted assistance, legal advice in relation to dealing with the estate. If there wasn't sufficient money in the estate to deal with certain legal costs, it will be the executors that would be liable for those costs. Sometimes, sadly, estates can be insolvent. So if there is any money in the estate, all the priority debts will be paid first. As I said, funeral, mortgages, the estate would sadly become insolvent. So a lot of questions we're asked is about care home fee planning. It is a very sensitive subject. A lot of people don't want all their estate to be potentially used up against care home fees. They are expensive. Sadly, people hear down the pub certain things that can be done in order to protect this. A lot of people are under the impression that you could put your estate in a trust to prevent this, that you could transfer your property to your children in order to prevent this. But this is sadly not the case. Local authorities are knowing that people are doing what they can to try and prevent care fees taking up all their estate, so they will look into things. Certain gifts that you make to children, for example, such as your property, which we would never recommend anyway. But if you gifted your children your property in order to avoid care home fees, local authorities can look back at that and say, why was this transferred? Was it to not pay for care home fees? So they could actually class it as deliberate deprivation of assets and still take that property into account. Similar to trusts, if you were to put money into a trust and you had a reasonable, foreseeable need to go into care, so if you knew you were going into care in the next few months, local authorities can have a look at historical transactions and still take those into account. A lot of people think there is a 7-year rule in relation to gifting money for for care home fee planning. So the 7-year rule has got nothing to do with gifting money out of your estate for care home fees. The 7-year rule is in relation to inheritance tax. So any gift you give over £3,000, if you survive 7 years, it will fall out of your estate for inheritance tax purposes. If you gifted something and didn't survive 7 years and it's over £3,000, then when calculating the value of your estate, that gift will be classed as part of it. But there is no time limit on gifting assets to try and avoid care home fees. It is a very complicated subject. There's no right or wrong answer, there's no definite answer. It is something we certainly suggest you take advice on.
Like that.
A lot of people think that putting their property, putting their estate in a trust would have benefits. Now, a trust certainly can be beneficial depending on somebody's circumstances. Trusts can be beneficial to protect against care home fees in some scenarios. Say, for example, it was a married couple trying to protect assets. A trust could be beneficial if you have a beneficiary who is sadly disabled and may receive means-tested benefits all their life. A disabled beneficiaries trust could ensure that they benefit from your estate. Any future state benefits wouldn't be affected by it. Some type of trusts are good if you think beneficiaries aren't good with money and wanted to make sure that this money wasn't squandered. But a lot of people just say, I want a trust. Hearing that a trust, someone said that a trust is good, but what's a trust for? What's the intention of this trust? What are you trying to achieve? Do you understand the costs? Do you understand the tax implications from putting something in a trust? And effectively, a trust could mean that the asset is being taken out of your name and put into a trust now. Do you want to lose all control of something like your house and put it into a trust, which means you wouldn't be able to sell it and purchase a new property if you wanted to? It's a very complicated area of law, which people just think is an easy option, and it's not. You should take expert legal advice, anything in relation to trusts.
One thing that I learned from interviewing Davina was that if you wanted someone to write a will for you, you don't necessarily have to instruct someone who's local to you. And that's because these days it can be done virtually. So with this in mind, I asked Davina what the benefit would be of using her services, given that she's in the East Midlands and she helps clients all over the UK.
So of course, the beauty of being able to do everything remotely is, although I'm based in the East Midlands, I can see clients nationally, internationally, through virtual means. So a benefit will get the highest quality legal advice, but for regional costs.
So if you wanted to instruct Davina to write your will, we asked her what the process would be and how long it would take.
So if you were to come to me for an initial appointment to discuss your will, we'd have an initial chat. I'd go through your circumstances, a bit about your assets, what your intentions were in preparing a will. From that, we would give you the relevant advice, whether you needed any inheritance tax advice, whether you'd like to plan for that, what your personal circumstances were, see what wills would be appropriate for your circumstances. We would then prepare a draft from your instructions. We would send that to approval. Obviously, if you needed to make any changes or additions to it, we would be able to do that for you. And then as soon as you're happy, we would arrange for it to be executed correctly. It all depends. So our initial appointment shouldn't take more than an hour. We would get the drafts to you within 7 days of the initial appointment. And from then, as soon as you're happy with that, we would arrange for you to come in and sign it. Because obviously wills aren't valid until they have been correctly executed, we would advise that they are signed as soon as they are approved, just to make sure that everything has been finalised.
As I said earlier in the video, there are various options available to you when it comes to writing a will and testament. And to find out more about these options, have a look at our video, Writing a Will and Testament. However, if you wanted Davina to write your will, we asked her how you would go about instructing her.
So if anyone would like to discuss preparing a will, discuss preparing powers of attorney or assistance with the administration of the estate, then please feel free to get in touch. We can arrange an initial telephone call to discuss it further.
Davina is based in the East Midlands, but works with clients across the country and overseas. So if you wanted to contact Davina with regards to her wills and probate services, her details can be found in the description box below. And if you want to find out how it is that Davina can work with clients across the country and overseas, have a look at our video called Solicitors for Wills Near Me. Now, just to be absolutely transparent, if you do contact Davina, I just want to make you aware that there are no affiliate relationships of any kind between Legal Connect and the lawyers that we interview. We have absolutely no financial interest in whatever you choose to do. It's our objective to interview the experts and ask the questions that you want to know the answers to. For more information about wills and probate, take a look at some of the other videos we've made in this series. And please consider subscribing so you can be notified when new content is added to the channel. Thanks for watching.